Excellent. Okay, I'll get my gavel out and make it official. And good afternoon. I'm going to go ahead and call this session of the City of Gig Harbor Hearing Examiner to order. For the record, today is Tuesday, May 17th, 2022 at 1:30 p.m. We have one item on the agenda today. This involves numbers PLSPP 18-0001, PLCUP 170001, PLDR 170184, PLALP 18-0008, and PLCPA 170013, involving a request to short plat an approximately 4.4 acre property at 9411 Burnham Drive into two lots, one approximately 1.6 acres and the other 2.8 acres, for the development of a mixed-use multifamily complex with 78 apartment units, a recreation building, and professional office space located within 6 new structures. My name is Andrew Reeves. I'm a hearing examiner with Sound Law Center, who the city has selected to hold certain land use application hearings like this one. And today it will be my role to collect evidence in the form of exhibits and testimony to determine whether this proposal complies with the city's comprehensive plan, zoning ordinances, critical areas ordinances, and the specific requirements for approval of several requests in this instance, including approval of a preliminary short plat, a conditional use permit, an alternative landscape plan approval, and design review approval. To that end, I received several exhibits in advance of the hearing that I had an opportunity to review. These include a staff report prepared by city staff, as well as an addendum to that staff report, information on the notice that went out in relation to the application, as well as today's hearing, some comments that were received in response to the notice of application and notice of hearing, including comments from reviewing departments and agencies, as well as several comments from members of the public, information on the project itself, including the various plans, a conditional use permit justification and project narrative, information on the review that has occurred with the city's design review board, and I'm sure we'll speak about that, but the project has appeared before the DRB, as it were, several times, an interested party roster to clarify who would like to stay informed about what's going on with the project, the various project plans, information on the proposal, and then several technical reports, including information on stormwater, information on the environmental potential impacts and critical areas in the area, and information on the environmental review that occurred under our state's Environmental Policy Act, including the determination of non-significance, or DNS, that was issued for the proposal. Ultimately, these exhibits have been identified as exhibits A through W, and I'm going to admit them into the record now. Should anyone have additional exhibits they'd like admitted into the record, let me know when it's your opportunity to testify, and I'll go ahead and address admitting additional exhibits at that time. Speaking of testimony, all those that are not attorneys will be sworn in when asked to speak, and that's to ensure that we have a clear record, and ultimately, were my decision to be appealed under our state's Land Use Petition Act, or LUPA, the recording of today's hearing, as well as the admitted exhibits, would serve as the foundation for any such appeal. I may and often do ask questions of those that are testifying, not trying to trip anyone up, just trying to ensure I have a thorough understanding of the proposal so that within a couple of weeks of the record closing, I'm able to produce a decision that is hopefully clear and legally defensible. Finally, the order that we typically follow, and I believe we're going to follow today, is first we'll hear from city planning staff, who will give a brief overview of the review process that led us today and the proposal. Following that, we're going to turn to the applicant team, as it were, and Attorney Bill Lin will sort of guide the applicant team and have them present any additional information they feel that myself and members of the public should be aware of in advance of my making any decision on the proposal. After we've heard from the applicant team, we'll then see if there are members of the public interested in testifying, and if so, they will have that opportunity. Then at the end, we'll go back to the applicant team and planning staff to respond to any such testimony and answer any further questions as necessary. With that, I believe then we can get started, and I note that folks will generally remain muted until called upon to speak. Even if we were all in the same room together, I would not allow crosstalk, and I would try to ensure that everyone is treated respectfully and no one talks over each other. So that's the system we follow, whether we use the remote meeting platform like today or if we're all in the same room together. With that, I'm going to go ahead and get Carl DeSimas sworn in on behalf of city staff. So thank you for being here. Do you swear or affirm to tell the truth in the testimony you give here today?
I do.
Thank you. And could you clearly state and then spell your name for the audio and explain your role here at the city?
Carl DeSimas, C-A-R-L-D-E space S-I-M-A-S, and I'm the principal planner with the city of Gig Harbor.
Great. Thank you, Mr. DeSimas. And my tracking of the exhibits A through W made sense with what you were hoping I'd review in advance of the hearing?
Yes, Mr. Examiner.
Excellent. Well, go right ahead, sir.
Oh, thank you very much. I would just add up front that in addition to the description that Mr. Reeves provided of the proposal, which was accurate, that the project would also retain a portion of the site in its natural condition, protecting a non-fish bearing stream that would also include a 25-foot stream buffer. The site is located within the B2 General Business Zoning District, which allows multiple family dwellings through a conditional use permit. In order for a conditional use permit to be granted, consistency with specific codified criteria must be demonstrated. The applicant has provided their own justification of how this project proposal will meet those criteria, and staff has provided its own analysis on pages 11 through 12 of the staff report, ultimately finding the use and proposal consistent with said criteria. The city's design review board reviewed several design alternatives to the design manual at 3 public meetings and did recommend approval of those. Staff concurs with their recommendation, and the recommendation has been included as an exhibit to this report. The city's SEPA responsible official issued a determination of non-significance for the proposal on March 9th, 2022. Public comments were submitted, including 2 agency comments from the Department of Ecology and the Squaxin Island Tribe. All comments were recorded and a condition of approval recommended in response to the agency's comments, and no SEPA appeals were timely filed. After the staff report was published, staff received 3 comments leading up to this hearing date. Those comments have been transmitted to the hearing examiner and the applicant team for their consideration. Staff would note in response to the comments from the adjacent property owners to the north and south that the project proposal does include additional landscaping on the boundary per the alternative landscape plan. I would also note that the setbacks for emergency rescue operations referenced in the letter from Gig Harbor Fire and Medic 1 are not code requirements per the IBC or IFC. The city's building official and fire marshal has reviewed the comment and has no further comment to add relative to this request. The imposition of such a condition to what has been requested would likely have impacts on the overall site design. Upon further review of the case file on record here at the city, it was also discovered that the staff report did not include several comments submitted during the notice of application periods. A supplemental memo was prepared and submitted to the hearing examiner and the applicant team prior to the start of this hearing. The memo and the associated enclosures have been added to the official hearing record and will be included as exhibits to the final order. All comments were recorded at the time of their submittal and were considered during permit application review. Finally, staff does find that with the imposition of the special conditions of approval found on pages 16 through 18 of the staff report, the project proposal is generally consistent with all applicable state and local codes and could be considered for approval by the hearing examiner. Concludes my report, Mr. Examiner.
Great, thank you. A few questions for you before we move to the applicant team. First off, you've noted that the zoning is the general business zoning designation, and we're in the mixed use district overlay. Is the comprehensive plan designation identical, I guess, throughout the city, and specifically in this area? Would it be also B2 or general business zoning, or general business would be the comp plan designation?
Well, I'm not sure I understand the question. The comp plan designation is mixed use?
Mixed use, okay. Sorry, in some jurisdictions, the comp plan and the zoning don't have the same designation. So here, the comp plan designation is mixed use and the zoning is general business zoning B2. Is that accurate?
That's accurate, yes. And there's also a mixed use district zone overlay in this area, but the applicant chose not to utilize those provisions.
Excellent, okay. The next question I had to do with sort of process. So this began back in, it looks like February of 2018. And the application for the preliminary short plat was deemed complete, I believe on February 6th of 2018. Is that accurate?
Actually, the project was first submitted back in August of 2017.
Okay.
And there was an inaccuracy in the original notice. So it was renoticed again in September of that same year. And then later in 2018, it was the applicant submitted a short plat application and added that to the permit package. So it was renoticed again at that point to notice the short plat application.
Sure. So I guess where I'm going with that would be, and you have analyzed this in the staff report, but essentially it's the city's determination that the project vested to that February 2018 date, such that even though there were some changes to the zoning code specifically related to density, the city's view is that because a complete application was received back then, that those new provisions related to density are inapplicable, i.e. the project would vest to the version of the code that existed at the time the application was deemed complete. Is that accurate?
That's correct, Mr. Reeves.
Okay, just wanted to make sure we were on the same page there. Sorry, checking my notes. We already talked about that, and that. Okay, I may end up having more additional questions after we've heard from the applicant, but I think right off the bat, we've answered the questions I had identified specifically in my notes. Did you have anything else, Mr. DeSimas, before we move to our applicant team?
I do not, Mr. Reeves. Thank you.
Great, thank you for being here. So next, I'm going to go to Attorney Bill Lin. Mr. Lin, if you could just state and spell your name and explain your role. And as you know, I'm not swearing you in because you will not be testifying, but you'll be guiding traffic. Or if you are testifying, I can swear you in, but I'll let you decide.
Thank you. William Lin, or Bill Lin, L-Y-N-N. And I'm part of the applicant team, and I have been since 2017. Although the progress then has been made that I'm going to talk about in a minute has very little to do with me. I've just been more or less an observer as we've gone through the process. What I think is interesting about this project is how much work has gone into it and how effective the team has been in resolving city concerns. When this project application was submitted, the city really didn't think much of this project. I think it's fair to say, and over, sorry, I've got a yard equipment going outside. An extensive effort was put into this by a team of people, some of whom are available today for your questions, traffic analysis, a lot of design work, a lot of grading analysis to a greater extent than you might normally see at this point. Landscaping, tree retention, multiple iterations of the site plan, and the result is approval of the design review board and support by the staff, which we're very gratified to see. But it does represent a significant amount of work by the team. I don't plan on addressing the CUP criteria. There is an exhibit in the record where the applicant submitted its version. It's been accepted by the city. I think it's fairly clear that the project meets the CUP criteria. One thing I think that's interesting is that it's a business district. So in comparing the other uses that might be allowed outright, many of them would have more impact than the proposal. So really a CUP in this instance is not to address additional impacts that the project would have on the surroundings as much as it is to just ensure that it fits and that it is compatible with its surrounding. But it's not a matter of its impacts being mitigated so much as it is just a matter of general fit. With us today is the owner of the property, Paul Conan. I think there are some other representatives of the ownership group. Jeremy, you've been introduced to. He's the project civil engineer. Stephen is with Jeremy's office and is the project planner. And really, we're all available for questions. If you have any questions about the grading plan or the storm drainage or anything like that. But I thought, in view of this last minute condition proposed by the fire district that I will address later, I thought it would be worthwhile to hear from Stephen as the planner for the project, just how the plan evolved and how it evolved to meet various city requirements that are much more extensive than in some cities and counties you work in. Very detailed design and landscaping requirements that required a lot of work here. And I thought it would be worth noting how much effort went into this between 2017, when the district was given notification of this project, and last night when they issued their comments. So this is very, very, very late in the process, and I kind of wanted to demonstrate a little bit how that evolution took place. So with that, I would introduce Stephen and let him talk a little bit about that process.
Okay, so I'm going to swear in Stephen Bridgeford. Thank you for being here. Do you swear or affirm to tell the truth in the testimony you give here today?
Yes, I do.
Thank you. And could you just clearly spell your name for the audio recording and then explain your role with the project?
Yes, it's Stephen Bridgeford, which is Stephen, and then Bridgeford is Bridgeford. And as Mr. Lin stated, I'm with Contour Engineering. I'm a senior land planner here at Contour, and I've kind of been along with this project for many years now. The project first came in our doors at Contour in 2015, as we were going through kind of our initial feasibility and design for the project, and got our first got the survey completed. We discovered that there was an encroachment from the northern property into this property. And there was some delays on the project getting that encroachment squared away through the boundary line agreement process. And so that encroachment kind of is represented by that irregular boundary line going along the north, where over the years things gradually just pushed into the property. So as I kind of looked back at the project and to kind of see how it evolved over the years, when you kind of take a look at the overall site plan from what we originally submitted to what's there now, it's vaguely familiar. It's fairly similar. However, there's been a lot of details that have changed. We worked with architect Ross Deckman and Associates and landscape architect Nature by Design. And our initial goal from day one was to try to get this development on this fairly complex topography site to meet outright the design manual for the city of Gig Harbor, which, as Mr. Lin said, is a fairly detailed document. However, as we kind of worked through that multiple iterations with Mr. DeSimas at the city and another planner who's no longer there, we realized that we could come up with a better design if we engage the design review board to look through some design alternates. The biggest challenge, as I kind of said, with the topography was the requirement to retain trees within the building setbacks, avoiding any walls throughout the site over 6 feet, need to balance grading overall to keep cut and fills within 10%. And that kind of idea of how do you respect the natural grade? How do you create a multifamily development where the buildings, fit into the natural topography rather than the natural topography is morphed to the building. And it seemed like every little adjustment we make over the course to get the site to work, is going to push walls too high or is going to make grading too big. Grading quantities too big or encroach into the tree protection areas. And so we just needed to engage with the design review board and have them present some designs to them and get their recommendation for some alternates, which included a few walls over 6 feet, the removal of some of the trees within the landscape buffer, and some flexibility in grading. Their idea was if the earthwork quantity is being removed for something like a storm pond or the parking garage under the one building, that's not really the same as kind of forcing a hillside into a flat site. So we were also able to provide an ADA compliant route from Burnham Drive into the site. So kind of every resident would have an accessible route from the property itself down to Burnham Drive, which is fairly notable considering the site topography. I think our road comes in at about 14–15%. So through a couple of pathways, it's not the most direct route, but it's which is, be much more desirable if you could just come in the same place, but it still gives somebody with limited mobility or the ability to get down to Burnham Drive from the property.
And sorry, by route there, Mr. Bridgeford, you mean a pedestrian or a non-motorized route down to Burnham?
Non-motorized. I think a lot of sites like this we see in the past are you accomplish the accessibility by a motorized route by saying that a vehicle will transport people to and from the site. So that allows people to get down to Burnham Drive and utilize the seasonal transit stop and pedestrians to move to and from the site. So kind of over the course of the plan, as I kind of mentioned, we added a parking garage to limit the visual impacts and to provide more parking stalls. We kind of endlessly tweaked and adjusted building pads up and down to kind of achieve those grading needs and that need to respect the natural topography. And kind of every time we kind of came in and adjusted the site as finely tuned as it got towards the end, it seemed like those changes were, you kind of almost had a snowball effect. Everything needed to kind of get tweaked out further and further as refined as everything got. And so, in all these design changes, we had to make sure we were still conforming and complying with all the requirements of the municipal code, the building codes, including fire code, and then, the city staff and any other regulations. I think that kind of summarizes the challenges of a property. Of what we went through into design, and every tweak involved the landscape architects, the project architect, the building architect to go through and adjust building elevations, roof lines, and so it's a lot of trickle down, a lot of redesign, a lot of adjustment to get through to the city's approval of the conditional use permit.
And I guess to that end, Mr. Bridgeford, if you're the right person, could you speak to the sort of late request that came in last night from Gig Harbor Fire and Medic 1 related to their desire to see, additional setback between, it looks like, landscaping and some of the residential structures, specifically, I believe, to access second and third floor with ladders, and kind of what shifting would do or not. Are you the right person to speak to that, Mr. Bridgeford?
I don't think we didn't have any time to, I don't think anybody on the team had any time to analyze the impacts it would have. I mean, it appears as though it would require, fairly substantial adjustments to the buildings. Moving, we don't have, there's just not kind of this additional flexibility to just push things around. And I think, as Mr. DeSimas with the city said, these are not codes that we had any awareness of. It's not codified in the IFC. Our architectural team had no ability to design around these requirements.
Sure. Okay, more generalized questions for you, if I could. Could you just sort of speak to what the short plat accomplishes and the sort of the thought process on, you know, why the applicant would like to have this be split into two parcels?
I don't know. I don't know, Bill, is this?
I can probably address that, Mr.
Oh,
Examiner.
sure. Whoever, sorry, I was just going down my list. So Mr. Lin, did you want to touch on that?
Yeah, I can tell you the origins of that, and the closer we get to approval, the less important it may seem, but that is in fact the reason that the project is vested. The city elected a new city council that had a significantly different view of growth than had its predecessor. In the meantime, this project was several years into development. It was this was viewed as really the only realistic use, because if you go by the location, you'll see that it's kind of along the middle of along a corridor, but there's not commercial type traffic. So given the topography,
the Hihi or whatever,
yeah.
Is that right? Okay, kind of in that canyon part of Burnham Drive.
Exactly. So
Okay.
while it might be suited for some industrial type uses or more intense commercial uses, the topography did not at all lend itself to that, all these conflicting requirements. So it really became imperative that the project have a multifamily use. So faced with the prospect of likely changes, the applicant team decided to file a short plat. So literally it is a vesting, candidly, it is a vesting device in this particular case.
I appreciate your candor. So there's no sort of this stuff is on this portion and this stuff is on this portion in a, some grand important way. It was more to retain our vested property rights. We need to submit a short plat, and I don't have all the documentation, but I am assuming that even at the time the short plat was being submitted, the basic concept of 80 or so multifamily along with these other uses was thought through. Is that right?
It was well underway, and like Mr. Bridgeford said, the basic concept hadn't really changed after the feasibility analysis. So.
Great, thank you. So yeah, it would be there have been other attorneys in other circumstances that have sort of tried to use the vesting, do a short plat without any plan for the property at all, and that is not what happened here. Here there was a plan, and this was a sort of, a means to an end, but it wasn't being done, with a last second,
Right.
without any significant forethought. You can agree with that.
It was a very comprehensive submittal, if I recall, and there was a lot of detail that was that went into the division of the property. So it was, yeah. It wasn't a race to the courthouse, as they say.
That good phrase. So that makes sense. And then back to Mr. Bridgeford. Mr. Bridgeford, could you just briefly touch on sort of, or someone on your team, how will stormwater be addressed on sites, and what manual do you believe you're under? I don't know if Gig Harbor has changed what manual it's using since 2018 and now. And there's certainly a legal quandary on, whether stormwater provisions vest or not, and maybe it's a non-issue, but if someone could, whoever's the best person on the team to speak to that particular issue, that'd be great.
And I can turn that to Mr. Haug.
Okay, let's get Mr. Haug sworn in. Thank you for being here. Do you swear or affirm to tell the truth in the testimony you give here today?
I do.
Thank you. And could you just spell your name, Mr. Haug, and explain who you are for the record?
Jeremy Haug, Jeremy. Last name Haug, Haug. I'm a project engineer with Contour Engineering.
Great. Thank you for being here, sir. So if you could just speak to sort of the stormwater plan and also touch on the applicant's take on which manual they're going to be working under, et cetera. That'd be great.
Right. So, so when we assess the stormwater for this project, there's actually in the preliminary set of plans, there actually is a preliminary storm drainage plan. Currently, the project has 2 separate underground detention tank systems. One on just north of the office rec building, and then one larger system in between buildings D and E. And all the site generated stormwater would be treated and then routed through these 2 systems before entering the storm system within Burnham Drive. So they are both, when these were initially preliminary designed, they were following the current manual, which was in place at the time. And I don't recall what manual that would be, what year that was, but when we go through and do into the civil permitting, which is the next step in the project process, we would use whatever current manual the city has adopted at that time.
Okay, so that takes care of that thorny issue. So the applicant is under the idea that as they move, were I to ultimately approve this and the process were to move forward, the applicant would review stormwater under the most current manual that's been adopted by the city, i.e. the applicant is not taking the position that the stormwater code, as it were, vested back to 2018. Is that an accurate assessment?
Correct.
Great. Any other engineering issues you wanted to touch on while I have you on screen, Mr. Hogue?
No, I think between Stephen and Mr. Lin, they kind of covered all the big hurdles on the site. You know, beyond topography, stormwater was a relatively simple challenge to overcome in regards to the project, as opposed to topography and accessibility and all that. But no, I think it actually, from where we started and the process through, I think it ends up turning out pretty well as far as how everything flows and everything is graded out. So, yeah.
Great. Well, thank you. The other question I had, again, if there is a person on your team, Mr. Lin, there was several folks in the comments that brought up concerns about the either current or pending construction. I haven't been over there in a little while, but on Gig Harbor North Road, and if that would cause impacts. And maybe Mr. DeSimis is actually ultimately the best person to speak to any potential, how that interplays with Burnham Drive. I don't know if I saw anything that had specifically addressed it, but I don't know if anyone on your team has any thoughts on that, or if Mr. DeSimis might be the best person to speak to that particular issue.
Mr. Holst is here too. He would, I'm sure he's happy to be pointed out, and I think he might be the one most likely to have information about that, but I don't know.
That's fine, Mr. Holst. Would you be a good person to hear about on this particular issue?
Sure.
Okay,
No problem.
I'll swear you in. Do you swear or affirm to tell the truth in the testimony you give here today?
I do.
Thank you. And could you spell your name for the audio and explain your role with the city and the project?
Yeah, thank you, Mr. Examiner. My name is Aaron Holst, AARON HULST, and I'm interim city engineer here at the city of Gig Harbor.
Great. Thank you for being here. Go right ahead, sir.
Yeah, and I just first wanted to make sure I understood your question correctly. Was the question related to kind of construction traffic that might be delayed by the construction of the site, or long-term traffic?
I'll be honest, I wasn't 100% sure in reading the comments exactly what the concern was. And so maybe, my question wasn't a very good one. My sort of read on it was there was some concern about how that construction on Gig Harbor North Road, or maybe an extension of the road to Burnham Drive, was going to have some impact. And then this was an additional project. I couldn't fully figure it out myself. So my apologies if it's not a great question. I was just hoping for some clarification, which is part of why this process happens.
Sure. Yeah, and I can speak to kind of transportation impacts of this project in general. When a developer project is submitted to the city and it's in its land use stage, what we do typically for a project like this is we require the developer to submit a TIA, or a transportation impact analysis, which this project has done. We review it thoroughly, and once we kind of go back and forth with the particular developer on the TIA and get it to a place that we're both in agreement with what's stated in the TIA, that we agree on kind of a number of trips that the city has adopted. What we've adopted is that we look at the PM peak hour trips that are going to be generated as a site to determine the level of service at intersections within the city. So this particular site, what they landed on with the TI they prepared was it was going to generate approximately 50 PM peak hour trips, 50. So once we agreed on that, we send that over to a consultant that that maintains our city's transportation model, and we update this model every time we have a project that receives land use approval. So this, the developer pays a deposit, our consultant runs those 50 trips in this case through the model, and it assesses where those trips are going to go in the city. And in this case, or what the model does, it looks at if there's any intersection failures based on our adopted level of service that are going to happen as a result of this project. In this case, there was no new intersection or link failures as a result of this project, and therefore we reserved 50 PM peak hour trips for the project in our concurrency model. I could speak a little bit to the, I guess I could guess at the construction impacts of this project. I mean, it's.
If I can stop you and unpack that for one sec, just for those that may not be transportation experts that are watching. So the city has adopted levels of service, or LOS, throughout the city. And one of the things that is done, especially with plats in particular, but often with CUPs as well, but the city is trying to ensure that the new trips and the new traffic that is generated will not cause a failure, or LOSF, I believe, in this circumstance. And so long as you're not causing those levels to fall below a certain level, am I correct in thinking then in the city of Gig Harbor, the project would be meet concurrency standards? Is that an accurate assessment in your mind?
Generally, yes, this project certainly meets concurrency standards. Our level of service is not just F across the board, it's different for different intersections, but yes, generally this project meets concurrency.
Great. So now that you've unpacked that, if you just could speak to if you have a sense of what that construction concern was, that would be great.
Yeah, and I could guess at it, and maybe the applicant's engineer is better to speak to it, but this project is required to construct frontage improvements, and per city standards and ecology, stormwater runoff standards, they're going to have to punch in a construction entrance, so that's going to go in first likely, and that'll get a lot of the construction vehicles off of the roadway and onto the site. So I don't have too much concern about that. We have processes and standards in place to take care of that. And then related to the roadway frontage improvements, when the developer constructs those, I don't think, we definitely wouldn't allow a full roadway closure. So it's something that they would kind of propose a traffic control plan, and we would work with the applicant to get that to a point where it was approvable. So, yeah.
Great. Thank you. Mr. Lin, based on that, did you want to go back to anyone else on your team related to that issue?
I don't think so. I thought it was a thorough answer.
Okay. And did you want to call on anyone else or speak to anything else before we hear from any members of the public?
Well, I do want to speak to the fire comment, but I can certainly do that at the very end, and that might be more efficient.
You know me too well. That was my plan, was we'll hear from the public, and then if we want to get into the nitty gritty on those issues, we can do that right at the end. Does that work for you, Mr. Lin?
Yes, thank you.
Excellent. Okay. Before I go to the public, Mr. DeSimas, did you have anything you wanted to chime in before we hear from members of the public?
I do not, Mr. Reeves. Thank you.
Excellent. Okay. So looking here, I see I have 2 people identified as attendees. I believe the raise hand feature is enabled here on Zoom. If you are interested in testifying, you can hit the raise hand button in the bottom of the screen, and that will raise your hand. And if you do that, we will give you an opportunity to testify about the project. Okay, so we've got 2 folks identified as attendees, a fragrance-free Karen and a Shelby Meyer. I'm just going to give you few more seconds here. If you would like to testify, please hit the raise hand feature. Okay, nothing thus far. So if you're having struggling with the technology, keep trying. I am going to go back to Attorney Bill Lin to speak to the comment from Gig Harbor Fire and Medic 1 and his thoughts on the comment itself. If the applicant would like some time to maybe respond in writing, whatever he wants to do. But go ahead, Mr. Lin, your thoughts on how you'd like to address that particular issue.
I think I can cover it here now, but I'm happy to submit something else if you want. Before I turn to that, I just, as a follow-up to what Mr. Bridgeford said, there's an Exhibit D is the DRB decision, and attached to that are several 3D renderings of the entrance of the project and what its appearance will be as a result of the proposal. And I just thought it was worth looking at, and really sort of a remarkable level of effort for a project that you know, at this stage, to have this level of design and rendering. And that's what helped the DRB, I think, make its decision. It could see how the grading would work in the real world and what those actual elements would look like. So I just think that it, not necessarily right now, but if you could take a look at that at your leisure, that would, I think, be instructive. So let me turn to this district comment that we got last night. And we may be paying more attention to this than we should. I personally always get concerned when there's an agency that has a life safety function, and I know that that has a special degree of concern, and so we want to address it thoroughly and without being shy about it. I think it's important to distinguish 2 different bodies here. The district is a firefighting organization. That's, if you look at their website, that's what they do. They fight fires. They make inspections, they do prevention, but a lot of that's in the education area. They don't have adopted standards. They don't have any rules that have to be followed. They don't even have a formal role in the decision-making process on land use matters. They're an interested party. They sometimes have comments, and so they're placed on the list of parties to whom an initial notice of application is mailed. If you look at Exhibit G, you will see that they were among those who received a notice of this application in 2017. And they were advised in that notice that there would be a design review process and a site plan review process and a SEPA process. They also had an opportunity to become a party of record and receive further notices and a more complete invitation. They did not elect to take on that role. So basically they got notice and they did nothing for 4.5 years. In our view, while they had a status as a potentially commenting party, they relinquished that rule when they let this whole process go by without any meaningful involvement. On the other hand, the city has its own fire role. They have a building official whose title is actually the Building and Fire Safety Officer. And so that, or director, I guess the title is. So that person, who happens to be Paul Rice, I checked to see if he was available today to participate, but he had other engagements and hadn't planned on being here. So he's not, but he is the person who's charged with enforcing both the International Building Code, which of course has its own fire protection organization, basically setting aside different use types with different fire prevention requirements and various and sundry requirements that are above my level of knowledge. The city's also has an international fire code that specifically addresses things like accessibility to the site and accessibility to the buildings, and it addresses sprinklers and other things. The counterpart to the building official under the fire code, the International Fire Code, is the fire chief. That's the position. And that's also the position that Mr. Rice holds as the city's building and fire safety director. He, in contrast to the district, has an actual role in this process. He's been a participant throughout. He's involved in the whole city review. He would have looked at this project a number of times with these various accessibility and other fire safety issues in mind. He has codes, the two I mentioned, and no doubt others. And so he has a role. He's participated in that role. He's provided comments. One of the conditions in the staff report comes directly from him. So the process has worked. Fire safety has been taken into account, and in the way that's anticipated by the code. And I know you know this, but as is apparent from Mr. Bridgeford's testimony, the city's regulations are many and myriad and sometimes overlapping. I mean, it's very hard, and he indicated that even with their best efforts, they had to get some leeway from the city on some things, the height of a wall or the amount of grading, in order to make the project work as it is. And you get to a point where every little thing you change modifies something else and brings you out of compliance. So this was a concerted effort. It would have been great had the district chosen to participate and offer its input at a time when it could have been meaningful, but at this point it's not. So as a result of the tardiness of their comments and the fact that they really don't have a role, and the fact, because this is a Life Safety Act issue, I mentioned Mr. Rice's role. It's not as if the issue hasn't been considered. It's just been considered and balanced by the city in a way that achieves all of their goals, not just fire safety, not just tree preservation, but all of the city's goals. So we request that condition be not be incorporated. And again, if you're interested in anything further from us, we'd be happy to provide it. But I think that is really a complete answer to the request, and particularly in light of Mr. Bridgeford's discussion of the effort that has gone into this planning process.
Sure. And to clarify, you said, Mr. Lin, you spoke with Paul Rice, but he was not available today. Is that accurate?
I emailed him this morning to see if he was planning to be present. He told me he was not. So he sent his comments, I think, through Carl, mentioned that he had spoken with him, and I think Carl said that he'd reviewed the condition and was not changing his recommendation.
Okay, why don't I have Mr. DeSimas, unlike you, under oath. Maybe Mr. DeSimas, can you sort of speak to that issue? And when I say speak to, this obviously would be testimony that I can include in the findings on. Can you sort of clarify that Mr. Rice saw the comments and he believes that the health safety concern has been adequately addressed throughout the last 4.5 years of review, such that the city has determined that it does not think an additional condition is appropriate, or not, whatever go right ahead. How about I let you talk for a minute?
Thank you, Mr. Reeves. Yeah. So we did receive this comment, and Mr. Rice did receive the comment. He reviewed it. We had a discussion this morning about it, and the way that Mr. Lin has characterized it is accurate, in that there is no code requirement for something like this. The project has been reviewed a number of times by Mr. Rice himself, and he has applied the IBC and the IFC to the letter of the law. And so we wouldn't necessarily support the condition, but we also wouldn't necessarily
Require it?
we wouldn't necessarily require it, but we also wouldn't necessarily have any issue with it if it were incorporated. I guess I can say it's not.
Sure,
it's not,
if it was, I guess, if it were an easy fix, right, and the applicant elected to make some minor changes, you would be in support, fine. But if it's based on what we heard from Mr. Bridgeford, Mr. Hoag, and the record, it sounds like, every minor change at this point has dramatic domino effects because I'm familiar with the topography generally of the area. I know it was I described it as a canyon right there on Burnham, right? This site would be sort of uphill from Burnham. And I think the rendering that Mr. Lin directed me to, I have looked at it, and it shows a pretty steep, kind of slope that fake people are walking down. So it would appear to me that any change, even if it's only 2-3 feet here or there, could have dramatic impacts. So I guess one thought, Mr. DeSimis, would be something to the effect of, if the applicant is able to make a change, or elects to make a change, city staff has no issue, but city staff would not require it as part of the proposal. Is that a sort of an accurate assessment in your mind?
that is accurate, Mr. Reeves. Yeah, there is no nexus for us to require such a condition.
Excellent. Okay. And did that settle that issue for you then, Mr. Lin? I think I understand kind of the applicant's view and the city's view, and it was good to hear that Mr. Wright actually talked to Mr. DeSimis and verified that he has no life safety concerns related to that particular issue.
Yeah, I just to put a little finer point on the practical problems. As I read the district's proposal, even a tree or a plant that would grow to be a tree that was within their area that they were concerned about they would not want there. And the city has already, as I understand it, approved this landscaping plan or in substantial part approved it. So there may be conflicts between requirements that really can't be met. So if it's some kind of a voluntary provision, I think that's fine. It's good to know of the concern. It's good to be aware of it, but as you've noted, changes at this point are of consequence.
Right. Difficult to change course midstream, as Bob Dylan once said, I believe. Probably not the first, but that said, you brought up something there I wanted to quickly ask about. My understanding, I think, is that through the consolidated review process, I, as the hearing examiner, technically am making a final decision here on the short plat, the CUP, and I believe also the design review and the alternative landscape plan. But if I don't need to do that, and some of that's already been done as final administratively, let me know. But my understanding is I technically should have conclusions in my mind that address all four of those things. Your thoughts, or Mr. DeSimis seems to be agreeing with me, but
That's correct, Mr. Reeves.
okay, did that track with, again, my role is limited to the extent that the DRB has looked at this thing, I think, in actual public meetings 3 times at least, right? And they have, the conditions that have been proposed incorporate what DRB has suggested would be appropriate, alternative designs. The alternative landscaping has already been addressed by the city. But just to ensure that I don't miss anything in my decision, I want to make sure I have a conclusion addressing at a minimum those 4 things. Does that make sense to you, Mr. Lin?
Yes, that's what I understand.
Okay, excellent. And then along those same lines, because I do always ask, again, not, the staff has not recommended incorporating the request or condition that's proposed by Fire and Medic 1, but the recommended conditions from Mr. DeSima's staff report, the applicant, any issue with those recommended conditions?
No.
Okay. I think at this point, and again, nobody, the folks that are in the attendee group have not tried to use the raise hand feature. So I think we now have someone. Okay, so I have the person identified as Karen, or fragrance-free Karen. Hi, I'm going to swear you in. Do you swear or affirm to tell the truth in the testimony you give here today?
I do.
Thank you. And could you spell your name and, well, state your name and then spell it for the record, please?
Yeah, my name is Karen Mashburn. It's Karen Mashburn.
And I apologize, Karen. Was it Mash with an M or Nash with an N as in Nancy?
With an M as in Mary.
M as in Mary, Mashburn. Okay. Karen Mashburn, thank you for being here. You had a testimony you wanted to share?
Well, we're just, we live across the street from it and down the hill from the site, the building site. And there has been problems in the past and not too far past about runoff, especially when, during a high rain season. We're concerned about that, as well as it's a 2-lane road. The traffic is really picked up. Anytime there is an accident on the freeway, it's like a parking lot in front of our house. Getting in and out is difficult. Pollution is, car fumes, especially with a low pressure system. It comes down to where we live. We're downhill from everything. We're concerned about, if you decide to widen the road, what happens? Which side of the road are you going to go on? And also for the traffic going in and out, a potential of 160 cars coming in and out of the new building site. That's quite a lot of traffic, certain times of the day especially. Is there going to be a merging lane? How is that going to work? Is there a plan for that? We're just curious.
Okay, I will see if we can get someone to speak briefly to these issues. I don't know if you were able to review the staff report or any of the plans. They are available for further review, but Mr. Bridgeford, maybe could you, or Mr. Hogue, I don't know who the best person would be, just briefly speak to, I think stormwater you had touched on, but maybe you could explain, at least in terms of stormwater, what the likely, would there be detrimental potential impacts on neighboring properties, improvements potentially for neighboring properties, and then the in and out in terms of how people get in and out of the site, you or someone on the team. But if you can at least start with stormwater, Mr. Hogue.
Right. And so per the, the current manuals for stormwater, we are required to detain or mitigate any new runoff from the site to forested conditions. So it would be released at a rate that would be as if the site was fully forested and into the city system within Burnham. So there should not be any drainage beyond that that's collected and tied into that Burnham system. As far as the vehicles and traffic going in and out, I guess, we did have a traffic engineer prepare the traffic impact analysis. And as Mr. Holtz has pointed to, that, there's improvements through Burnham there in the works for the frontage of this project. So there was no requirement for any kind of emerging lane or anything like that. I guess there's quite a few questions, I guess, wrapped in there. So I'm probably missing a few.
Sure. I mean, I think, I think it would be a challenge to require any applicant to deal with what happens when there's an accident on 16. That's, I think, where in any community that any of us live in, there's always going to be that. People now have apps on their phones and Waze, and it directs people off freeways through neighborhoods, and that's going to be a challenge to deal with. I think in terms of stormwater, the specific concern or question would be, in your mind, there would be no further or increase in stormwater runoff to neighboring properties. I know sometimes it's actually less because there's an engineered system rather than a free flow of sheet flow of stormwater. So am I correct in that particular?
Right. Correct, Mr. Examiner. Yeah, we can't really, per the manual and just best management practices, we can't create any adverse impacts on neighboring properties with stormwater. So, and that's just standard for the, the industry.
Sure. And if I could go back to Mr. Holst for just a sec, I think one of the questions was, is Burnham Drive expanded as part of this project? And my understanding is there are improvements being made to Burnham Drive in front of the property, but the Burnham Drive itself, they're not adding lanes or anything to that effect. Is that accurate?
That's a correct assessment. There's not going to be any lanes, additional lanes required of this project. In the TIA for this project, they analyze whether or not additional turning lane or a turn pocket was required based on that the project would have to mitigate, and it was not.
Okay.
And then, yeah, their frontage improvements are going to consist of what we call half-width roadway improvements. It's a little bit unique with this particular project because we do have a city project that's kind of on a, it's kind of, the design's running concurrently with this project, and we're not 100% sure which one's going to go first. But that, long story short, that roadway section is going to be a little bit different than our standard roadway section, but it's going to be mostly a shared use path is the majority of the construction. So the roadway will stay similar to as it is today, and there'll be a 10-foot wide separated shared use path instead of a sidewalk adjacent to this development.
Okay, and by shared use path though, that's non-motorized, correct?
Correct.
That would be for walking the dog or maybe a bike or something to that effect. But my understanding was, depending on who gets there first, the city is working on that path all along that stretch of Burnham Drive. The applicant is fiscally responsible for the portion in front of this project. But if they finish quicker than the city, they might build it out and the city will join it. Or if the city's ahead, the city will build and then the applicant will pay its share to the city. Is that a accurate assessment of how that's going to work?
Correct. That's the way this project has been agreed on with the city and the developer, and that's the way it's also conditioned.
Okay. Mr. Lin, did you want to call on or call on anyone else on your team or speak on any other issues here at this point?
No, thank you.
Okay, and I'll go back to Mr. DeSimas on behalf of the city. Mr. DeSimas, any final thoughts or comments from the city based on what we've gone through here today?
No, Mr. Reeves.
Okay, well, I think now I have everything ultimately that I need to take under consideration for this proposal. So it is my intent to do so. And here in the next 2 weeks, I think we got a holiday coming up, but the plan would be within 2 weeks issuing a decision on this proposal. And ultimately, as we spoke about a few minutes ago, I'll technically be addressing the short plat, the CUP, the design review, and the alternative landscape plan, and all of that will be addressed in my decision. And finally, Mr. DeSimas, question for you: if there are members of the public that are interested in this project, is there an easy way they can get a copy of the decision that is ultimately produced? Is it ultimately made available on the city's website, or can they email Michelle Thomas? What's the best way forward for those that might like to see what the final outcome is?
either of those options, Mr. Reeves, they could email us directly, Michelle Thomas at mthomas@gigharborwa.gov, or they could go through our permit portal and go directly to the permit using any of those permit numbers, and they could find the decision posted there.
Excellent. Okay, and that was one more time, M. Thomas, Michelle Thomas, mthomas@gigharborwa.gov. Is that accurate?
Correct.
So those that are participating, if you reach out to Ms. Thomas, she'll ensure you receive a copy of the decision here in a couple weeks when it comes out. And I think then that concludes our hearing today. So thank you to city staff and the applicant for being here, being available to answer my questions. Thank you for members of the public for participating. And with that, we'll end today's hearing, and I wish everyone safety and good health. Thank you very much.
Thank you.